You can, well, when you have a disciplinary code or policy in place, you need to ensure that the employee has signed it, and by signing it, that means they've read it, understood the terms. If the employee has signed a policy and doesn't understand the provisions of the policy, they are well within their rights to query that with the owner of the enterprise or with the HR or IR department to request clarification on any particular provision of the code.
So, I know from the little legal interaction I've had with you and colleagues over the years on the show, that in a court of law, for example, let's say a criminal case, it needs to be proved beyond a reasonable doubt. When it comes to disciplinary hearings, is that the case, or could it be on a balance of probability? They probably did it, as opposed to, it was done beyond reasonable doubt.
It has to be on a beyond a reasonable doubt. You have to have evidence to substantiate the allegations that are raised against the employee, and the judiciary is quite strict. If we look at cases from the Labour Appeal Court and the Supreme Court of Appeal, they're quite strict in terms of the disciplinary process needs to be done correctly from the start. It cannot be rectified in the courts. If the process has not been done properly, if evidence is not properly presented at the disciplinary inquiry, then that dismissal can be overturned.
Voreshka, so let's say something happens at the organization, there's a disciplinary, and there's a judgment that's brought out, and the employee is unhappy. What would be any recourse for that employee? Should they be dissatisfied with the outcome of a disciplinary hearing? What's the next step that would you recommend they do? Go straight to court, or we've got this wonderful thing called the CCMA, and we've had commissioners over the years here helping people. From your perspective, what would be the best course of action for someone who's dissatisfied with the disciplinary hearing?
You would first need to go to, it's either the CCMA, Alan, or the bargaining council. So if your employer is part of a bargaining council, then you would have an opportunity to refer your dispute within 30 days. And I see a lot of clients that aren't aware of the time periods with regards to referring an unfair dismissal dispute. So whether you go to a bargaining council in which your employer is a member of, or the CCMA, you need to refer that dispute within 30 days.
All right, so it is time bound then.
Absolutely correct, yes.
And I know from previous discussions, the CCMA does not charge employees for their services. It's a free service for employees.
Absolutely. And there's a very rarely do the CCMA award a cost order against either party, because they're there to facilitate disputes and to resolve disputes amicably.
So when does a matter go to the Labour Court, for example?
Disputes that go to the Labour Court would be where you are dissatisfied with your outcome at the CCMA. It's what we refer to as a review process. So let's say you have been dismissed at your company for insubordination, and you've gone to the CCMA, you've got a finding that the dismissal is considered to be procedurally and substantively fair. You can then refer your dispute, and let's say you're unhappy with that or dissatisfied with that, you can then refer the matter to the Labour Court on review. It's a 6-week time period in which you have to lodge this review application. But what's important in terms of the review process, Alan, is that you have to ensure, or you have to make out a case that the arbitrator has made an error.
So you got to prove the arbitrator has made a mistake.
Correct. Based on the evidence that you presented at the CCMA, you've got to show that the arbitrator has made an error and that a different commissioner hearing the same evidence would make a different finding.
But the difference here is that when you are at the Labour Court, you're going to have legal representation and attorneys with you, right?
Absolutely correct.
So let's say the Labour Court judge issues a judgment that you are unhappy about. The law is a beautiful thing because it's giving you another step where you can go and appeal this, right?
Absolutely correct, yes. You can appeal it.
Which is the Labour Court, Labour
Appeal Court, yes.
And after that process, so the Labour Appeal Court, you'll have to prove that
It's an appeal process, so it's not a review. Okay. It's an appeal process, and you normally what happens, it's before 3 judges. and they're judges that normally judges that don't sit as labor court judges. So they will normally sit as high court judges, and they preside over the matter.
So